in opposition. Lordship will find at page 33.
Now, where is the, when have you submitted this order?
My Lordship will find at page 42, Lordship will find, I'm sorry, page 43. Thereafter, they call me for that inquiry. And my Lord, at page 44.
42 is
42 is when the inquiry officer says that he will only speak the disciplinary procedure, the charges, because they were also inquiring into charges which were not there in the charge sheet. So here the inquiry officer says, I will only restrict myself to the charges in the charge sheet. Thereafter, at page 43, they say that I am to come up with a witness.
no. When have you intimated regarding the order?
They have an intimation of that. Lordship will find it page 45. I'm sorry, madam, page 48. In reference to a letter of consent stated, Honorable Court has not passed any order saying that disciplinary proceeding in any instance. Rather, Honorable Court has directed status quo as on today's hearing. That is to the for calling in all my witnesses, calling me again, allowing directly to participate, my lord. Having knowledge, they know there is a status quo order. And in fact, now they have started up another disciplinary proceeding that is for subject matter of the order.
Who are the contemnor here?
My lord, the inquiry officer and the person who has written the letter at page 40.
Where is the inquiry officer? Why have you made inquiry officer?
My lord, because the inquiry officer said that at page 46. Inquiry officer is supposed to
How can it be contempt? He said there is no order is given.
my lord, the status quo.
Status quo order, you should give them. That is what I am asking. Where is the communication that you have intimated that
They were requested the intimation is at page 44.
this cannot be?
If
Where is the order? Therefore, she said that give me the order.
If people kindly find page 48, they know of this passport.
She knows because by page 48,
yes,
this person has directed her to proceed. How is the contempt?
But this person directing her to proceed is itself a contempt.
That will be contempt. By H. Doctor, that can be contempt.
My lord.
Prima facie, you may issue a notice, but not against this inquiry officer.
The second
that may be different issue, but it's a contempt jurisdiction. We are as strict in both ways.
Both sides,
yes. Okay. Issue notice to respondent number.
There are two contempt petitions. In this contempt petition, there is only one respondent, the other is the plaintiff. There are two contempts.
So we are not issuing notice there. We'll close it. Or you withdraw and with the liberty to file a press giving due inquiry and making a statement. Withdraw with the liberty. Next case.
Here,
sole respondent notice.
I'm obliged.
Returnable. Steps good.
I'm obliged.
Right.
His daddy was for that to detect my benefit.
Where is the order?
Order is at least 26.
Where is the FIR?
After your lordship will get that page 22.
Who are you?
I am your lordship, this Fakhrul Islam board. Your lordship will
TD
kindly
is there. You are the main man.
no, your lordship will kindly seek court.
Only new ground is some medical documents. that
No,
can be
not
done.
only medical, your lordship. All your lordship will kindly see there is an RTGS done by one person, your lordship. And on the basis of that, your lordship, certain amount of money has been transferred from one person to another person. Now, your lordship, both these two persons, your
Mm.
lordship, ultimately it will have to be your lordship conspiracy by three persons, your lordship. Both these two persons are out. One is granted bail, the beneficiary, your lordship, interim, the anticipatory bail. Other has not even been sought for by the police, your lordship. Now, the only person, your lordship, against whom these people are there, your lordship will kindly see the third paragraph of the FIR, your lordship. It may be mentioned that Mr. Abdul Mannan Hazari, from whose account, your lordship, the amount has been transferred. And Mr.
Where that on 21st July.
Next, your lordship, fourth paragraph.
That it may be mentioned.
So and so are known to each other and having deep intimacy. That means, your lordship, that there is a conspiracy, your lordship. But your lordship, ultimately, your lordship, what had happened? The amount is transferred from one account
But
to
the
another.
conspiracy could not have executed but for you.
Lordship,
Because you are the custodian of bank's money.
no, your lordship, I am not the custodian, your lordship. That's your lordship will kindly come to page 23, your lordship. Page 22. What role I have, your lordship?
Hmm.
23, second paragraph. That it may be mentioned that the period between his leaving its bank on 30 August 2023 and he's again visiting the bank on 31st August 2023, searches were made to trace out the connected papers regarding the state RTGS, but these were found missing. Attempts were made to contact Fakhrul Islam Borbhoy over telephone, but he could not contact it. Further, it may be mentioned that since 22nd July 2023, Mr. Fakhrul Islam Borbhoy stopped visiting bank branch and he could not be contacted over his telephone number, which was given to us. Further, it may be mentioned that Fakhrul Islam Borbhoy used to assist in doing manual work in bank, which are generally done by the sub staff. It was to be done by sub staff, and that is arranging bank papers such as keeping vouchers, checks, etc. in proper place. On that day also, he was assisting in arranging the bank papers, including papers connected with the state RTGS, your lord. RTGS I cannot do, your lord. It will have to be done by an officer, your lord.
That is where you have taken that. Because these officers are so overburdened, so they are keeping all these people, giving
Lord.
you are getting some salaries from
Lord.
them,
Lord.
and you take advantage because you are not a regular.
No, your lordship will kindly.
But for you, this could have been executed by these two others.
But your lordship, that's my case, your lordship. Then how can others be granted bail, your lordship?
We do not know.
Beneficiary.
Can it be a ground that the others are granted bail in spite of materials? So you are entitled for
No,
bail
no,
for.
that's not my
Suppose
case.
there are materials against them and they have been granted bail. Will it be binding upon this
No,
court
your
that you should
lordship,
be?
not will by binding.
Then-
Your lordship, on the ground of parity, I have come. On the ground of parity, I have come.
What is the question of parity in bail?
Ultimately,
Show us something, parity on bail. What is the parity on bail? You have a specific role attributed in the case diary. We'll see.
but your lordship, ultimately, your lordship,
If
whether
state is not coming for cancellation of bail, not coming. It's up to them, but we will not give you parity.
but ultimately your lordship will kindly see, your lordship, that the amount has been transferred from, and your lordship, another aspect. Has there been any material that they have again paid some money to me, your lordship, then also they are good, but without being beneficiary, your
Or
lordship.
you are intelligent enough. Now they have given you cash.
No, your lordship, that is not,
Will they transfer it again to you?
that is not there, your lordship. Ultimately, your lordship, your lordship, the bank officials, your lordship, to safeguard their own scheme, has, your lordship, everybody made me a scapegoat, your lordship. I am not even a grade 4 employee, your lordship. Contractual, your lordship, not even contractual, your lordship. They have, your lordship, outsourced certain work to certain agency. On that basis, I was engaged. Your lordship. I don't even cannot even handle the computer, your lordship. And your lordship will kindly note, your lordship, if at all, your lordship, money has been transferred to RTGS, there will be a message message will be sent to this person, your lordship, the person from whose account the RTGS has been done. RBI has a guideline, your lordship, on RTGS, your lordship. Your lordship will find that the beneficiary, the bank of the beneficiary will inform the RBI about the RTGS, then the RBI will inform the bank concerned, Your Lordship, and there will be a message sent to the other person, Your Lordship. Now, in spite of having all these things, Your Lordship, it has been done, and everybody, Your Lordship, ultimately, collusion is between bank officials and these two persons. Now, I was made a scapegoat, Your Lordship. That's the case, Your Lordship. My case, Your Lordship, on my instruction.
If you are inside, then they can get hold of the bank employees who were with you.
No, Your Lordship.
So better be there so that they can press out those bank employees who
No,
are involved with you.
Your Lordship will kindly see, Your Lordship, and Your Lordship, whether Your Lordship, by putting me, Your Lordship, behind bar, Your Lordship.
That is to everywhere. What is the necessity of putting a person behind bar?
No, Your Lordship.
There is no requirement of police custody. In every cases, will on the day one protect you, go there, get interrogated and come back. Where is the question of violating Article 21?
No, Your Lordship.
In every case, we'll
No,
do that.
not in every case, but in this particular case, Your Lordship, in this particular case. Because of, Your Lordship, my poor background, I was made a scapegoat by everybody, Your Lordship. That's the case, Your Lordship. Those with, Your Lordship, beneficiaries, everybody else, Your Lordship, is outside, Your Lordship. Now, Your Lordship, the police is after me, Your Lordship. That's the tragedy for me, Your Lordship.
You have some more tragedies.
Your Lordship may kindly see whether custodial interrogation after all this, Your Lordship, is required or not, Your Lordship.
That cannot be a ground for giving you second degree.
Ultimately, Your Lordship, issue of custodial interrogation is the only, Your Lordship, aspect, Your Lordship, which Your Lordship, this honorable court probably, Your Lordship, in my
No. Other aspect is that this is a anticipatory bail is a privilege.
No, that's I,
Whether on the material that privilege can be granted.
Lord. And
And
also,
on earlier occasion, we thought that this is not a case. You
Your
cannot
Lordship.
be granted the privilege.
I am.
Now you are here again.
Lord.
So you are in a more slippery.
No, I know, Your Lordship. I am on a sticky wicket, Your Lordship. I am on a sticky wicket. But, Your Lordship, the manner in which, Your Lordship, others got the benefit, Your Lordship. As a beneficiary was, Your Lordship, allowed to go on bail, Your Lordship. And there is a specific affirmance that the person who is the beneficiary, he said that I will not hand over the money, Your Lordship.
There is a statement of other accused, Mr.
It is there, my lord. Last portion of the, my lord.
I will cooperate, Your Lordship, in every manner. Stringent condition, Your Lordship, may impose, Your Lordship. But looking at the subsequent developments and, Your Lordship, the
One is Azizur
Azizur
Rahman
Rahman is-
Laskar.
Yes,
from whose account, Your Lordship, amount has been.
withdrawn.
No, he is the beneficiary of Azizur Rahman.
The money was transferred from Abdul Mannan Hajari.
Hazari.
Who is Fakrul Islam? You are the
I
proprietor.
am.
He is the petitioner.
the FIR would not have been there, had there not been possibility of disciplinary proceeding against the bank official.
No, story is something different. Bismarck, this man is just a self-help group.
Yes,
Huh? It is what is called SIG,
yes,
Joint Liability
joint
Group.
liability.
So he has taken loan from Joint Liability Group.
Yes.
Now he has returned this loan from different persons' account. That
I
is
mean,
the story.
the bank employees were put to trade.
Mm.
For which they had to give their deposit, return the money to this Mannan Hajari. From their pocket.
Definitely, because for your agent,
Yes.
the third
Yes.
person is suffering. His client took loan from the beneficiary.
Right.
Now he demanded that he return me the money. Now you don't have money, but bank is having money, and you are having the process to do this form fill up and all. So you filled up the form. Bank manager put his stamp, and money was transferred from this account to that account.
And last IOS note may be seen, my lord. There is categorical finding from the bank statement that money was withdrawn by this
Maybe
Aziz
the other accused who has been granted bail, beneficiary, he is also a victim of your fraud.
That I,
That case there is to reflect.
that I will have to be sure.
That reflect. This is not a kind of conspiracy. This is the return of loan, but not from your pocket. It is from the, because therefore he will not give you return with the money that you have said.
But your lordship, RTCS, your lordship, the account holder will have to put his signature.
No, of course, he has somehow managed it. But there may be some bank official involved. We do not know. So therefore, your interrogation is necessary. At
I
this
will-
stage.
I will, your lordship, make myself available for it. I will make my,
Because he is having a self-help group. You have a liability of 8 lakhs rupees to that self-help group. Now he was demanding the money. You have transferred 7,30,000. Now whether transferring 7,30,000 some other bank employees are there, that may be rejected.
oblige.
You do a contractual job. Why is the requirement of 8 lakh rupees loan you take? Better be there for someday. At least there will be some cost cutting. At least you will have some days at top state hospital. Rejected.
Oblige.
Well,
43 minutes I have a prayer, my lord. My lord, I could not go to the case there today.
You go to it
Today-
after Bihu. He is enjoying interim. Okay.
in interim.
Interim.
Highly obliged.
We have given
Tomorrow we can do it. Otherwise,
Sir,
Tuesday will
sir,
be
we will
like-
because what happened is this case, initially it was a second bail application. We
Right.
rejected it. Mr. Mahajan more or less convinced her. So we thought we'll apply our mind. But while going through the case diary, the mind changed. We are not in favor of Mr. Mahajan. So we call it back again to be spoken. Then we granted, because it was before the prior date to the application, we granted him a interim return the seat.
It may be
Sir,
fixed.
that-
No, we have not made out our mind.
That aspect may not have been
Ah.
that phone call record of this man that
Ah.
that may be possible. It was not there that I don't think.
Okay. Basically, the person committed suicide. Material so far collected implicates that this man put some pressure
Pressure.
upon this person. There is some demand of money. Phone calls were there between these two journalists. The journalists demanded money. They were arrested. They were released on bail. Isn't it? They
Yes.
were arrested. They were
Yes.
released on bail. And the other person whom this person met earlier date, those statements implicate this man, how he has. So we go through it
My lord.
and whether there is any communications between the
Myself as a
accused and the victim. That part you can go through it.
Malat, that part may be thought for that was not there, but you said that. Otherwise, it
No,
will be
there, I think there may not be any communications between you and,
in the order it is there.
If it is not there in the case, there is not there.
okay,
No.
we'll,
Possible,
no, understand. You say that there are full cons between the parties.
Malat, that was wrongly told by the PP when Lord.
Okay, we'll consider that. Whatever in the
My
city
lord.
is city.
My lord,
Uh,
my anything.
Okay,
Date
Mr.
will be
Mr.
fixed.
Das, Learned Counsel submitted that he may we require some time to go through the case. Like,
Fine.
accordingly, matter is adjourned and be listed on
19 minutes.
19-1, interim order passed.
Highly obliged.
We'll have to see the next,
My lord.
how proximate is this.
44 minutes again, bank fraud.
When this Kalidas Burman. But where is the affair, Mr.
Well.
Gogoi?
FIR is at 12. Dr. May also read my lord para 6,
Para
Fine.
6.
page 5, para 6. These are the new facts. And steps.
Seems the story, if Mr. Gogoi is correct, let his statement be recorded. We'll come back.
Case there is there.
Is there what is the person alleges that these loans were not sanctioned without consent of this person, the loanee, and therefore there was a fraud. He was not even aware of the loan account. Now Gogoi has taken a stand that yes, loan was there. I was the manager, but there was a default. So to pay the interest, what the bank did is they of course, without the consent of the person, they created another loan account and got it paid to themselves. Okay, now his loan amount is enhanced. If that is the stand, let us have his
But if
statement.
that is the stand, my lord, why he has returned, my lord, once, my lord, in January 23, he
Return.
has returned 20,000 and in February 40,000. There is an agreement that he will return the money.
It is.
Yes.
Yeah.
There must be police station.
Let us take it.
My lord, this not maybe. I would say.
Let us,
The relevant person I am.
because
Relevant person.
our worry is that for maybe an earlier case diary,
From
the
the
genuine officer should not be put behind. Because bank job is definitely a serious thing.
No, no, so many bank fraud, my lord, now it is taking place.
Any bank official statements recorded?
Yes.
So whether it is statement is recorded post my 22nd December 2020. Thereafter I appeared,
Mm-hmm.
pursuant to the intent order of the route.
Mm.
I appeared again.
Intimation. Huh? No, I did not find it statement.
Lordship was already directed to appear and to record the statement. That part whether it is there or not. This
Okay,
part
you-
Lordship was already paid with.
Okay, I have already paid. Because in this idea we have asked him to appear. What is his statement?
I did not find it.
I thought he appeared. First or
Yeah.
third, second he appeared.
What is his statement? Can I ask you forfeit? What is because his specific stand?
Or what is the last date of entry, my lord? I did not.
Where do we get last date of entry?
Last date of entry, my lord, of the
Okay,
case
okay,
diary.
just tell me.
Because he
Last date of entry is 3 p.m. till 30 p.m. Date is 39.
30
My
September.
lord, post my lord 22nd
And,
December.
my lord,
Lordship
after
has
that
passed
case
out.
diary will be required, my lord.
Okay.
Yes, after that has not been.
Okay.
If required, he will appear again.
No, 30. Then his statements will not be there, my lord, because
No.
he appeared after 22nd December. Therefore, his statement is not there.
So Gogoi this document. Show him and we'll show him. That Pisha will reject.
Case is not that easy.
Mr. Das, but additional public will submit that he will require an up-to-date case diary for proper adjudication.
For the reason, my lord, he has made a statement that he has appeared before the
Yes,
IO.
yes, okay.
Okay, well, along with.
In as much as it's submitted by Mr. Gogoi that pursuant to this court order dated 22/12/2023, the petitioner has appeared before the IO and got his statement recorded. However, the case diary's last entry is dated 39/20/23. Accordingly, case diary is returned back and same be produced after recording, incorporating the statement of the petitioner on the next date when
First week of February, my lord.
if it is second
6 months.
6th of February 2024. In the meantime, the petitioner shall appear before the IO once again and record get his statement recorded. Yes.
I am permitted to return the city for
Ah.
updating.
I'm sick.
Right.
Yes.
If this interlocutory application has been filed
Mm.
for modification and vacation of the interim order dated 27/9/2023,
What is that?
which is at page 15,
IA.
I, in the I. And the relevant portion mallet is at page 15. Last paragraph.
Just a minute. Okay, who is the authority, transferring authority? You have the record, will decide the entire
They
matter.
were, in fact, they were asked to file an affidavit.
Where is the transfer order
The transfer order is at page 19
of the IA?
of the by which 3% have been transferred.
Hmm.
In my place, one
Comment to-
Abu Hanif Mukaddima has been transferred. He has joined. And due to this interim order, time in hanging position till then.
No, no, no.
Mohammed.
What is the incorrect statement made by my friend?
Muhammad? No, just tell me. Your name is
My name is Mahmoud Ali Hassan
Muhammad Ali Hassan. You have been transferred from
from
Thekamari
Kakamari
to
ICTS
Mankasar.
project to Mankasar.
And who is from? This is Abdul Momin Sakra.
Abdul Momin Sarkar from Mankasar to South Salp.
Mankasar to South Salmar.
Yes.
Okay. And who
And
is the petitioner?
Petitioner is Abdul Momin sir.
Abdul.
Momin sir.
So Abdul Momin Sarkar has been transferred from Mankasar to South
South
Salmar.
Salmara. And Abu Hanif Mukaddima Sardar who transferred from South Salmara to Kakamari in my. He has already joined.
Okay, have the record. What if it? So page 22 of repetition.
It is the same transfer.
Okay. Just a minute. Page.
Page
Is
20.
this IA?
A 19 method.
Okay. Where is the earlier order?
That order was never issued. That was never issued, and so how can that be modified, Lordship?
We want to see the record. We want to see the record. But record we want to see. Transfer cases, what is the requirement of it? We will see the record. If nothing is there, no malafide exercise of power or there will
Then that is all.
dismiss. And if
I have,
something is
I-
there that no, you are passing order and somebody requests, then you are changing order. We want to see the record because these are the clarifications. That clarifications can be given when the question is asked by the court. Under what circumstances this was written and what is this file? What is this order? Because you have everything number. You cannot delete a order number of an order because that will have a sequence, that will have an implication. These numbers SW11 so and so, this is have a implication. Record. Okay.
Only problem.
We'll keep it as a IA. We are not closing it. We'll decide both on when.
That thought that maybe we can decide in hanging position.
no,
I have
that
no
is not
position.
correct, Lordship. In fact, what
Okay, hanging
Yes.
immediately after view, but you have the record on 19, 28.
that is
Okay. Wait a second. The present application is filed for modification of an order dated. Order dated
Order dated
27/9.
27/9.
27/9/2023 passed in the connected writ petition, that is WPC 5696/2023. The respondent deputy commissioner has already filed an affidavit. However, for proper adjudication of this matter, the record pertaining to the transfer in question shall be made available, shall be required accordingly. List this matter on 28, 22, 22, 1, 2024.
In the meantime, after we
Okay. Interim order, passed earlier. Okay. We'll see the record.
yes, yes. If
What
there
is
is
the
nothing
FTT?
logical,
Record
I
is
do not.
In fact, sir, in the petition, no Malapati, nothing is.
No, why I filed the petition, lordship? Within a span of 1 year, 3 transfer orders are there.
Is
Violation of patent. Any right.
that is where the problem is. If you have public complaint, then it is a punitive. That may be punitive. Can the transfer be punitive? But there are some
Problem.
other judgment which is no. For
Yes,
the time.
yes, I have that, that's some.
Both sides.
I have that.
We'll have it, we'll decide the matter instead
yes,
of
Because
in a
otherwise,
transfer matter, vacating of stay and repetition, taking up the representation.
Because
otherwise, one of them is hanging position. No, both
no, he is
yes,
not hanging, lordship. In fact, an order has been passed. He has been attached to a particular place. He's not.
ultimately-
He, according to him, is hanging because he wants that share,
Yes.
which you also want as far as.
Yes.
Lordship may.
An application filed by the first wife,
Hmm.
the respondents are made with petition for
Hmm.
vacating the order date 2/1/2023,
Where is the order?
page 13. The operative portion your lordship will find at page 15, paragraph 6. Says, I may read.
What will be her share?
But share will be decided by appropriate forum. So far as her claim is concerned, it's the second wife. And his claim
No, no, forget about her. The children, 17.
is that,
Pay her.
Yes.
How much? Yes, madam.
But we filed our objection to the eight. We
Who will bring it on?
registered.
You ought to have made a mention. A whole pension is she is enjoying from how we
no, my lord, I have not received pension since 2012. The day, my lord, since the time of the death of my husband, I have not received any pension because of the application filed by the second wife claiming pension for herself. And when the department has initiated process of payment of pension, because the stay order, the pension was stopped, my lord. It is available at page 21.
No. You are the
First,
she is the second one.
this is the second one.
Who is getting the pension also?
My lord,
Nobody.
nobody is getting the pension.
Nobody is getting the pension till now.
And because of this interim order, the department has passed an order dated it's available at page 21, by which it was directed to stop the family pension which was payable to Srimati Pulumoni Mohanto, that is the first wife, the respondent in the main petition. Because of the interim order passed by this honorable has
No, otherwise also we are not getting any pension. So there is no meaning of that order.
yes, but they have initiated the process of payment. Process
So
was not started because of the application filed by the second.
so we will modify the order
Yes.
on the next date to the extent that at least for the time being there will be a share between you and her.
minor.
And because an area will not release at this stage. There will be an area salary that will have to determine later. But to survive both of them, they are surviving. When have you filed this objection?
Yes, it
Oh, yes, sir. Let it be on record. Okay.
That's the second paragraph.
Hmm.
The proposal cannot be no objection certificate by the petitioner. He has no objection to the bank.
My lord, by her. Is the
With the instruction.
You don't have any objection. Huh?
let's come on the next page.
So you also go get. Now you have stopped the pension to both of the parties. You be there for some time. You have your instruction. Give a copy to her. Whether children really their concern. Higher principal is stated that an objection has been filed in the IA on Mr. David. But same is not on record. Yes, Mr. Padgiri. They say that you don't have any objection. Giving a pension to the first wife. Your second wife.
Second wife.
Now
I am
they
seeking pension to minor daughter my.
no minor daughter will give. So have a consensus.
we also agree, my lord, that will pay for minor daughter.
Of course, minor daughter pay till her marriage or
In
what?
fact, GPF amount already drawn by her matter.
How much?
9 lakh something. But no money has been
Because
paid, my lord.
I was the nominee, the third. That's what
No,
the-
no, you may be the nominee, you are the first wife,
I'm the first.
but you have to take the responsibility of this child.
I am ready, my lord. There's no
And
Okay.
she
So
is,
you can't have a consensus and come back to this court when then people same is not on record. Registry to list this matter
after due vacation, my
on 22nd of January 2023 along with and take the affidavit in opposition file by the opposite party number one.
One.
Okay.
obliged.
Interim order pass करके फैलता है.
But if I have checked the office note, my lord, says,
Hmm.
my lord, no instruction taken.
Hmm.
But my clerk says, my lord, he has taken instruction 20%. Let me check, my lord. Maybe
The
next.
learned counsel for the petitioner submits that steps has already been taken.
Or my lord, I may be allowed to take this.
Okay, in view of office note dated 27/12/2023, the learned counsel for the petitioner pressed for and is granted 10 days time to take press steps.
Okay.
Please this matter
After
Ah.
vacation.
after please this matter 4 weeks after the steps are taken.
It is said.
No date. You have not taken steps after.
May I please.
Hmm.
Matter pardon family benefit.
Hmm.
The payment of family benefit.
Hmm.
So the fact is that
Hmm.
my husband was appointed on 11/11/1975 as secretary and his service was provincialized with effect from 22/9/1994.
When you were
Initial appointment was
madam
on
ready, we can go for
My lord,
11/11/1975.
but lordship, before that, lordship, may kindly have a look, the annexure 8 of my
I'll
affidavit.
come to that.
annexure.
Annexure 8 of my affidavit, page 30. Here we have written to the Pension and Public Grievances Department for relaxation.
Lordship,
What relaxation?
Before going to that, I'd like to submit before your lordship that two issues were discussed by your lordship by this honorable court lordship, similar to this my case lordship. And lordship come to a positive assertion with regard to the lordship qualifying service lordship and other is lordship regularization of lordship suspension period. These two issues are also involved in my case.
Which judgment?
Yes,
Lordship,
Lordship, take the judgment I have, here. Lordship has passed the judgment. But Lordship, in this case, Lordship, there is some dispute regarding the fact. Otherwise,
Lordship, in yes, Lordship judgment, Lordship, yeah, Lordship, paragraph number Lordship 6. Yeah, it discuss about the qualifying charge. Lordship 5 and 6. Paragraph number 6. Lordship.
Have you laid down any ratio?
Lordship, in this case, my lord,
So far, her affidavit in opposition also I have entitled. The post of this is a substance post of qualifying period of service 10 years.
agree.
Yes, tell your thought. Yes. How it is relevant, this judgment? No ratio is laid down in the given fact of that case. No ratio. Yes, I cannot remember anything.
My-
Yes.
Lordship, my case is that Lordship, he was appointed or my husband appointed on 11/11/1975.
75.
75. Thereafter, his service was subsidized effect from 22/9/19.
Appointment order, page
Appointment order is page 9, Lord.
page 9. Okay.
And I joined on Lordship 21st November 1975. That is at page 14. Joining is 14.
Then
Then, my Lord, I was allowed to cross the efficiency bar. which
forget
is
about all these that they have not disputed. Tell us when have you retired?
got determined from
What is
the
your regularization?
regularization Lordship is the page Lordship,
32.
Lordship. Page,
Huh?
page 20 Lordship. Page 20 Lordship. The effective was given Lordship
Page 20.
20. My name is at serial number 460 Lordship. Only 11 part I have. My husband got determined from service on 31st December 2003 Lord. So far my calculation is concerned Lordship. My regular period is 9 years, 3 days Lordship. 9 years, 9 months, 3 days Lordship.
Hmm.
As cadet secretary. And Lordship, casual period Lordship, non-regular period is Lordship 18 years, 10 months, 1 day Lordship.
So you initially joined as what?
Lordship, cadet secretary. Lordship secretary.
Kedar, Assam Kedar Management Cooperative Society. What is this Kedar Management Cooperative Society? It's a private society
No,
It's
no.
under the corporation department.
under the cooperative. So he joined in a 75.
75.
Subsequently, your service was regularized in
Regular.
2006.
With effect from 22/9/1990.
With effect from
22/9/1990.
22/9/1994.
1994. And my husband got retirement lordship 31st 12/2003.
31.
12/2003.
Your service was regularized in 2006.
Lordship, that was given a decision lordship, but we took it from lordship 22/9/2019.
1994. 1994. So prior to regularization, your husband expired.
Lordship,
Okay, but even after his death, service was regularized.
that was given a decision lordship for
Okay.
payment of pension, so similar. It's about 500.
Okay. Now, why your pension is not being paid?
My husband,
What is the stand?
lordship, my husband died lordship. Thereafter, I approached the authority lordship.
Mm.
It was forwarded to the accountant general office also. Accountant general lordship returned on the counter his qualifying period of service less than 20 years.
Mm.
This is only the, and so far they are
So
exhibiting
therefore, the period from 1975
Hmm.
to 1994
lordship
should be counted
counted. And
for the purpose of calculation of the pension. This is your case.
lordship,
Lordship, as per our record and so far the affidavit is concerned, my lord, his date of joining is 25/4/1989.
From 89 to 2000 till his death,
Yes.
when he expired,
2003.
31/12. What will be the period?
9 years.
You know what they do.
14 years,
14 years.
3-4 months or
What is the qualifying service?
20 years.
Lordship, for lordship substantive for lordship 10 years.
Substantive 10 years.
10 years. It is
So therefore, 10 years, you are having 14 years.
for retirement
For the
as well.
purpose of pension, where is the judgment?
But-
It should be counted. There are some communication,
Several judgments are there,
but our
we know,
we don't we
Honorable Supreme Court in opened the case, but it was not the preempting case lordship. Very recent.
show us the written judgment.
That is why lordship, the registrar has communicated to the Pension and Public Grievance Department in the year
There is
2020 regarding that for relaxation.
Now, what is the status of that?
That my friend,
Yes.
lordship, one order was passed by this court lordship. There are
And- department.
the rely upon some judgment of the Supreme Court.
Yes.
Regarding this Pension Public Grievance Department.
So have to instruct.
Will take
See, that period is even if their admitted stand is 89.
Yes, madam. And 14 years, 8 months.
Huh?
If his the date of joining is in 1989,
1989,
lordship,
died on 31. Look, what is the date of joining
Later-
according to you?
date of according to us, it is lordship 25/4/1989.
25/4/1989.
89.
And he died on
He died.
Right now, retired lord.
Huh?
Prior to his death, he died.
huh?
He got
30.
retirement lord before his death.
Okay, when he retired?
31/12/2003.
31/12.
2003.
2003.
So it's 14 years, 8 months, 6 days.
14 years, 8 months,
6
6
days.
days. And when was service was regularized? 22/9,
2006.
1994.
1994.
1994. By an order dated
And order dated
2006.
2006. 2000.
Year is
5/1,
2006. I also know. Huh?
5/1, 2000.
5/1, 2006. Okay. And 31/12, 2003 retired.
Lordship.
Qualifying services 10 years. Which rule?
For the pension rules for qualifying service 20 years.
20 years or 10
Not
years?
to 10 years.
Not 10 years. I think 10 years.
10 years.
20 years.
But no, qualifying service, he was regularized on 1994. So from 1994, he is a permanent employee.
Permanent.
Okay. From 94, if he is a permanent employee, what would be his qualifying service for pension from 94? Last page of the confirmation is whose responsibility?
It was the reply of the department.
Let Abdul Salam.
Twen-
Where is that? Show me the rule 20 years and 10 years both. Are you having the book?
One 186.
Which
Pension
page?
186 in my book.
That is for in case of temporary service.
Hmm.
Temporary service is different to
So
Right, sir.
according to you, from 1994, you are no more a temporary service.
normal temporary provincialized.
Provincial. So he's in a government. So from 1990, suppose a person is regular, suppose he is alive, when will he be entitled for pension? Hmm. Uh, uh, your serial number is? Your serial number is
My serial number
page
is
21.
Lordship, his serial number should be 460.
46.
In my affidavit, it is legible. I think that petition is not legible notification.
Four zero.
460.
460.
What is your name?
Abdul Salam Mia.
40
460, my lord.
460. There is no 460 here.
Lordship may kindly take up my affidavit. I have annexed it. Page 18.
Page
18.
Just tell me one thing. This is the list.
My lord.
This was issued when 2006.
Because
Before that he retired, is not it?
my
31/12/2003.
Three.
Okay, now see this. The government of Assam, sir, plus please read this,
which one?
that page 32.
Page
Your page 32. That document, that
Sir.
now.
The last one, Lordship.
This document. The first page of this document, page 7 or something like that. Your affidavit. 5th of January 2003. Page 7, internal page 7.
My
What it says?
in
part-
pursuance of approval of the Cabinet called on 23/12/2005 and considering the services rendered under Assam Cadre Management Corporate Society Limited prior to provincialization, the government of Assam is pleased to allow continuing to offer such services which effect from the initial date of joining in service as Cadre Secretary, as Junior Inspector of the following Junior Inspector of Cooperative Societies, whose services were provincialized by notification number 20. If that notification is required, I think 1994 notification. Nowhere it is annexed for granting the pensionary benefit, including DCRG, etc. by
So these people are included.
included.
Lordship, only
That's why we have written to the pension and
for
public
the
Affairs
purpose of
department.
releasing pension and DCRC,
Hmm.
that cabinet decision was taken.
So these persons are included in that committee. Where is your appointment and joining?
My appointment is at page 30. Page 9. Page 9.
Your date of joining is 1980 and we have given the wrong fact for this one.
No, no,
No.
I have
That's why
given
we
it
have
wrong.
asked. Because see, do you dispute this document?
Yes, sir, as per my paragraph 4, Lord,
There is a contradiction between your decision and his date.
And you
Date
again, your
is,
lordship may kindly.
See,
of joining.
you say these people are listed below are done.
Right.
Now he relies on a document of 1975.
Lord,
What would be if you retired in 2003?
Right.
60 years.
Again, your lordship may kindly come to the page number 23. Page number 23.
Lordship, the 1975 person is in serial number 147. He's Abdul Samal.
This reply was issued to me, lordship. Abdul Samad Mia joined as Cadre Secretary.
Where is that?
Page 23. Lordship. Page 23 of the decision.
RTI reply.
At the report. Lordship, date of joining is 21/11/1975. The source at the authority. This service was retired on Lordship, he released from service on 31/12/2000.
Who issued this? Who is representing this department?
Register of cooperative.
Who is representing this department? Madam, who is representing cooperative?
Lordship, additional register has.
No, who is representing this department?
Lordship, I'm
So what is your stand on this in the affidavit?
Lordship, in the affidavit.
And what is your stand on the page 11? 11th of November 75 and
Page 11, my lord.
page 11 and page 23. What is your stand in that?
Page 11, Lordship, as per department concerned, the name of the petitioner reflected in state number 460,
No, that is the different.
my lord.
Do you say that this document is incorrect? The date entered in the so is correct. Where is your statement?
That, Lordship, we
And
have
that this is a wrong information given.
paragraph 4 of
And
my
we
affidavit
want to know on what basis this information was given. See,
that
our concern is
2014.
that a genuine person should not
Yes,
be
yes, yes,
deprived.
my lord.
And at the same time, a non-genuine person should not get benefit.
Benefit.
That's all.
Right.
So you'll have to make a stand clear.
Lordship, in paragraph 4, Lordship, may kindly have a look.
No, tell us. Tell us.
Paragraph 4, we have written the petitioner, husband of the petitioner joined in the service in the year 1989, and his
On the basis of what? What is the statement? On the basis of record, on the basis of knowledge, tell us.
Lordship, may kindly have a look. Annexure 1
Annexure.
of my affidavit. That's not. It's a notification of 5th January 2006.
No, we understand.
Lordship.
Where is your affidavit?
Affidavit.
Paragraph 4.
Paragraph 4, madam.
What is your stand regarding these two documents?
These two documents, my lord. We have said the Abdul Salam is another person and her husband name is Abdul Salam Mia.
Actually, that is not the stand, Lord. Stand is
Take,
just
take your seat, take your seat. They are grilling her, not you.
But Lordship, we have written to the concerned authority. For
Why
their
should you rewrite if he is not entitled? Not entitled.
No, Lordship,
Or you
because
say he is entitled, therefore you have written.
as,
You cannot have both.
as per his date of joining 1989, Lordship, on the basis of that only we have communicated. At 1989 basis, my lord.
So according to you, he can still be granted pension.
Lordship.
Grant him. Then why should we make all this probing and fishing and
Lordship, the relaxation part is there, my lord, because he has completed 14 years, 8 months, 6 days.
relaxation under which provision?
Relaxation because 20 years qualifying service.
So power of relaxation is where? Page 21.
yes.
So he's
Past services subject only by following the good.
Ah.
Sign
that we have seen. 31. So according to, do you say that this is the list final, so they are entitled for pension?
if his date of joining is if it is 89.
Not in the, therefore, they are, so-
even then,
so
even then
you-
not.
that is
even
the, that's why I'm asking, that is the
Even
clicking
then
point.
not.
Yes.
The petitioner you're talking about, he is entitled to family pension.
Family pension.
Yes, we have
Even
provided-
now he is entitled. I wait for the department to clarify which date of joining.
Yes,
Yes.
75 or 89.
because what is your stand regarding
In
that?
paragraph
That's
13,
why I'm
madam.
asking this question.
Paragraph 13, my lord,
Paragraph 13.
of my affidavit.
No.
Family pension, regarding family pension only, we have.
No. Family pension will entitled.
No.
It's not an issue. Issue here is, why not pension from 31/12/2003? You will have to take a specific stand. No, he is not on such 1975. You are yourself is saying that the affidavit filed by this person,
Yes.
Sofiquddin Ahmed, paragraph 4.
Yes.
His whole determination of paragraph, what is the statement of record or knowledge? Let us see paragraph 4. With paragraph 4 is record. That
Yes,
cannot
sir.
be a record to determine his date of joining.
Yes.
That may be wrong also. Now, what is your stand about the RTI reply?
RTI is given in the year 2013, Lordship. I have to take instruction whether this information.
No, what
was
is your
given.
stand in the affidavit?
Affidavit is in 1989. That affidavit I have.
Regarding the document he has annexed,
Yes, sir.
have you replied?
That document I. Right.
Paragraph 10 and 11. What is paragraph 10 and 11?
The matter of record, hence the deponent has no comments to offer. The matter of record.
So this is correct. You do not deny it. Your
Because-
officer says his date of joining is this. He has annexed a what about your that paragraph? Annex.
Lord, may grant me 2 days time. I will produce the record, service record of the petition.
No, don't produce. Tell us which one is his date of birth.
Because the RTI replies
Third,
something different and
Learned
affidavit is
counsel
something
for the
different.
petitioner. Full stop.
Lord,
The-
kindly observe that it
To determine the claim of the petition for arrears of pension due to her deceased husband with effect from 31/12/2003, comma, the date of entering into the service as
secretary.
As secretary.
as cadre secretary of Gao Panchayat level societies is very relevant. Full stop. The petitioner has taken a specific stand that his entry into the service was 21/11 11/11/1975, and in support of such contention, he has relied on the order of appointment. She has relied on the order of appointment of her husband as well as an RTI reply within bracket Annexure 5 issued by Additional Register of Cooperative Societies, which discloses that the date of birth of the entry of the petitioner, entry of the husband of the petitioner into the aforesaid service was 21/11/1975. However, the respondents has taken it to be 25/4/1989 on the basis of Annexure
One.
Annexure 1 to the affidavit in opposition 5. Full stop. In that view of this matter, MS MD Bora, Learned Counsel for the Poor Person Department, seeks some time to clarify the actual position and to apprise this court the actual date of birth, actual date of
Yeah.
entry of the husband of the petitioner into the service on the basis of material available on record, including the materials on the basis of which the RTI reply was.
Deeply obliged, my lord.
Obliged.
To make only fix
When please this matter on
as per lordship.
22nd.
Lordship, before that,
22nd. See,
Obliged.
if he is genuine person,
Yes,
to
my
get
lord.
one family pension you pay in the meantime, we'll think of the area.
Lordship, 22nd, lordship may dispose of the matter.
Yes.
Deeply.
Well,
Yes.
that matter relating to matter, some anomalies matter regarding the matter 2017 ROK. But before that matter, can you have a look matter? Page 33. With the Assam matter,
No, just briefly say us what is your grievance.
in the ROK 2017 matter.
Hmm.
That, to become a staff nurse matter,
Hmm.
the basic qualification is matter either GNF or PhD.
Hmm.
Before that matter, before 2017 matter, the same case, same pay will apply. But ROP 2017,
Hmm.
they made two classification of the same. But ROP 2017, can you have a look at the ROP 2017?
Why this matter is listed here? No, bench 2, 3, do not know. This is nowhere related to areas of salary or
No, no,
pension
no,
or suspension.
It's related to salary.
That is challenge to a indirect challenge to a ROP.
ROP.
That these are anomalous.
Hello.
So this is not a case to be determined. This matter pertains to uh, a challenge to certain provisions of Assam services within bracket revision of pay bracket close rules 2007
17.
2017 therefore not related to the present batch. Accordingly, list this matter before appropriate.
Diploma.
Case, both cases, my petitioner paying area salary.
For item number 6, we have send the activity for getting to may agree for consent.
What is your stand?
The director asking the submission of a best proposal. Accordingly, the principal of the state school submitted his proposal on 3/6/2023. Now kindly see this.
You are getting the current salary.
So petitioner number 1 is retirement. Other is getting fine.
Then you are getting pension.
No, my
This is not pensionable job.
no. Yes, well, pensionable job, but this case is filing only for area.
No, do you understand?
Yes. Yes.
You are representing whom, Mr. Das?
Social justice and empowerment.
What is your stand? Why these areas are not being paid?
Due to non-receipt of some budgetary allowance from the government.
Can that be a ground? Now, how you are proposing to do this? Instead of filing affidavit, tell us that how you are proposing to pay it. That's all. What affidavit is required? File affidavit in where you need to contest. Tell us.
But we have sent a proposal to the government in the budgetary in this one.
Okay, when can you pay it?
Okay.
Who is the government here?
Now, social justice, we are on.
So,
We have placed the budget.
your directorate will send to the government in the social justice.
No.
Then
Social justice will send the same to the finance department. The budget as and when the finance department.
yes, Mr. Puja, you are in the finance. Why is this anomaly? So much many areas of salary cases, and there is no dispute that they are not entitled. If they are entitled, streamline it, pay it, and these are back areas. Supplementary budget will be. Or they may not, we may say that that is not due. So then you reject it. Give a reason. Proposal is sent. Expedite it. Yes, where is your proposal? 17th of March 2023 will be now in the 24th. Directorate of Women and to the principal school.
Best proposal submitted on 3/6/2023.
Where is that?
Yes, well, that instruction last case.
This instruction is given to whom? The standing councils are less equipped than the petitioner. The instruction addressed to you is with him, not with you. That is the difficulty. So you file affidavit, whatever is required, but we'll passing an order to update us. Claiming arrears of salary. The present writ petition is filed. Full stop. Mr. R.M. Das, learned counsel for the respondent, submits that they have made proposals to the government for release of the arrears of salary of the petitioner. The learned counsel for the petitioner, relying on a communication dated 3/6/2023 issued by Principal School of Hearing Impaired, Jorhat, addressed to the Director, Social Justice and Empower, Beltola, Guwahati, Assam, contends that by the aforesaid communication, a proposal for sanction of area salary budget for rupees 14,62,355 has already been sent by the said principal. However, till date, nothing is forthcoming. In view of such submission, Mr. R.M. Das is to obtain instruction and apprise this court on the next date fixed whether the petitioner is entitled for the arrears of salary, and if so, why the same has not been paid. Please this matter after 2nd of February 2024. Give a copy to him. You give us the instruction. You file affidavit or not, that is, these are not the cases to be filed.
Doctor.
It is a statutory benefit method. The lordship kindly the order my lord passed by your lordship on 22/06/20.
Yes, Mr. Devnath.
But my lord, kindly have a look at order dated 18/9, my
Hmm.
2020. Subsequently, we made the PTC also a part. The reason being, my lord, this area,
It is his name, son.
yes, the cause is
Yes. Wait. Aman. Yes.
Item number 9 and 10, my lord. 9 relates to my lord transfer. The lordship takes up first 9.
9.
That is restriction number
5424.
5424.
Yes.
Here, my lord, the impugned order of transfer, your lordship will find at page 55.
Some affidavit file that has come on record.
Yes, my lord, affidavit for exchange, my lord, bidding for exchange.
No, today's there's some.
Today, my lord, other case,
Okay.
other case, my lord,
I
that case, my lord, other case, my lord, I have received the copy. That few moments.
okay, because they made a
Yes,
mistake.
yes.
So could we proceed both the cases or what?
My lord, this is a transfer case.
Uh.
If your lordship can take up this transfer case.
What is two methods? What is the second case?
Second case, my lord, it's regarding my lord, what purpose has been given to me, issued to us. So that case, my lord, I approach this court. If your lordship now takes up, my lord, the order dated for it.
'89.
Yes, but
Okay.
now your lordship will see the impugned order, my lord. That is at page 55.
So transfer order is stayed.
Page 55. Page 55 of the Annexure 23. May I read out?
You are Ashish Kumar Datta.
Osim Kumar Datta.
Okay.
At present, my lord, Deputy General Manager, Market.
This is the impugn.
This is the ordering.
22/9/2023.
11/9/20.
No, a challenge is just a stay is at 22/9/2020.
Yes, sir. Yes. Now, my lord, this order, my lord, I have challenged, my lord, on various grounds, my lord. Number one, my lord, because as I have approached this court earlier,
That there
and
is
I
some compromise.
obtained a stay order, my lord. So this transfer order is, my lord, is in punitive in nature. Number one, my lord. And number two, my
You
lord,
are going for final disposal.
because I am already
We are
protected.
taking both the matters next
Yes,
week
my lord. Yes, my lord.
on reopening 19.
We
Huh?
are only worried about transfer because
No, you are worried. Only 4-5 days left.
Yes.
If you file an affidavit today,
Yes.
matter is directed to be taken together. It'll take
Yes,
up on
yes,
19th or 20th.
Yes,
You go through it.
my lord.
18.
But can it be
You have a date. We'll dispose it. You have the record of transfer.
on 20,
20.
20 is a Saturday, 21 is Sunday,
20.
22 Monday,
23rd.
23rd.
Give a convenient days as per the senior.
second is convenient, your lordship,
22nd.
the Monday.
22nd or 23rd.
24th,
24th.
22nd or 24th.
22nd or 24th.
24.
24th. You have the record of the transfer. We'll decide. Even if not the other, if you want to file something in that,
Fine.
file in that.
Fine.
Okay, we are not recording anything
Only matter that interim order.
till then.
Yes.
Please this matter 24th of as agreed to by the lord, but please will not say agree. These two writ petitions are taken up together as the parties, contesting parties are same. Will not say the issues are same, contesting parties are same. An affidavit has been filed in WPC 3452 today itself. Mr. N.J. Dutta may go through the same and if so advised may file reply on or before next Friday,
On or before 18th.
on or before 18th of
January.
on or before 19th of January 2023 and 2024. Please this matter on 24th and thereafter list these matters on 24th in the admission column. Interim order shall continue till then.
That will be it. I cannot part-time.
No, we are passing a common order
yeah.
in Kottagiri, on the next. Interim order passed earlier on in WPC 5424. Yes.
Lordship, I was suspended in the year 2017 and was instituted in the year 2022.
Hmm.
If that no disciplinary action has taken, no notice has been issued,
Hmm.
no reason has been given
Hmm.
for what purpose I was suspended.
Hmm.
My lord, I that suspension period has been regularized
Hmm.
and I have not paid no reason was given.
So let them have a disciplinary proceeding against you. Will direct it.
5 years. or
That
6
you
years.
want or what?
For what reason I have been suspended?
Tell him the reason why you have
In fact, on the last occasion, the Lord was directed us to obtain instruction as to whether any memorandum of charges and the allegations has been issued to
Then
the petitioner. Although our report has been received, but that statement of allegation and a memorandum of charge has not clearly been specified. Now, the director on 3rd of this month has written to the DEO to furnish all the details within 13th of this month, January. So, Lordship may fix the matter after
Bihu.
immediately. Lordship will have the
You do, if you do not want to proceed, regularize his suspension
Lord,
period, because
Lord.
there is a provision in the,
Lord,
if you do not proceed.
Lord.
Okay. Mr. P. N. Sharma, Learned Standing Council Education Department, transport and is granted further 1 week time to obtain the instruction as instruction in terms of this court order dated
order dated
20/12/2023.
Lord, Lord.
20/12/2023. Please this matter on 29th.
Lord.
Not your side.
Safety first, matter. Suspension substitution matter.
Substitution challenge.
Suspension not paid matter. Yesterday I follow up matter. He got day for yesterday.
Now what to do?
Now that matter. That invocation of the suspension order matter.
When we suspended, suspended.
Suspended on matter.
What is the order of
2040.
suspension? Huh?
2040 2020. So 3 months gone, my lord, immediately after coming.
You have been arrested or what?
My
You were arrested.
Arrested, my lord.
When have you intimated?
I have intimated my lord on 21/6/2020.
Where is the communication?
That to page 20.
Just tell us the dates. You were arrested on
I have arrested on 24.
24, 24,
2020.
24, 3,
3/2/2023.
3, 2003. Page, FIR page.
FIR I have not connected, but that order my lord, that connector 1.
Okay. Okay. Now you were put under suspension on 24/3.
24.
Page 16. Page
FIR is there,
16.
my lord. The copy is there.
Huh?
FIR is
Yes,
page-
that is there. I have seen that. That's why I have
my-
asked you.
my- Thereafter, my lord,
At page 17,
my lord,
isn't it?
my lord, my lord.
Page 17 is the FIR.
Then, oh,
Now, so it's a team suspension. Okay. Now, where is the bail order?
bail order, I have not annexed, but I have made a category.
When bail granted?
Bail, my lord,
Para 6 also. He was allowed to go on bail by the learned special judge Assam by the order dated 4/5/20. Page 6 para.
That's it. Bail granted on
4/5/20.
4/5/2023. Page statement paragraph.
Page 6 para 6.
Page 6, paragraph 6. Then when have you intimated?
that 21/6/2000,
Where is that?
paragraph 7, annexure
21/6/2023.
annexure
Annexure 3, page.
page 24, type copy 20.
Okay. What is your stand? No
Charge sheet
review.
has been given.
Huh?
Charge sheet has been given within the 3-month period after that. Charge sheet has, they have also annexed the charge sheet also.
What is
proposed
that?
decision also. Annexure 5.
Page.
29.
Charge memo given on 7/9/2023. From the intimation, within 3 months we have been. Now what to do?
But your lordship, so has to that under Rafet Ali this has been done. So under other Sote, your lordship, the para 22 next para, your lordship. Cannot be that.
Now what is the stage of inquiry?
Why is the review, my?
He has
Who has to matter as per the audit because they have to review. Review means they may keeping
Uh-huh.
when they may review that I may be allowed to continue. Where is that review, my lord?
This is the audit secretary judge. Paragraph
21 and 20. Last bit.
Now, what about your that we during departmental proceeding you need to require him to under suspension? That will be required, isn't it? Time to time. It cannot be time immemorial, isn't it?
Otherwise, that
That period is done, but after 7/9/2023, search memo is filed 9, 10, 11, 12. Suppose we search memo is filed on 7/9. Within from 7/9, if we take it on 21/6, within 3 months we have done it because after when he's in jail you cannot give him a search memo. Now 7/9 to 7/12. You will have to have a review that no, for the purpose of departmental proceeding, he may manipulate, he may do this return order, we need it suspension to be.
Remain suspension
Remain
till departmental proceeding. Or he may be allowed to continue.
See, we therefore direct that the currency of suspension of order should not extend beyond 3 months if within this period memorandum of charge is not served on the delinquent officer employee. If the memorandum of charge sheet is served, a reason order must be passed for extension of the.
That is fine. That repeat.
but in this case, that was possibly not done. That is why this case, even though this was the observation, right?
So there are some specific direction. Which paragraph here?
This was the specific para 21, I think, is the specific direction, your lordship, but para 22, then court said that in this case, I think it's not required. It was not done or something.
The paragraph.
But one thing, if I may say, your lordship,
Mm.
so what your lordship query is that instruction I don't have. So if
You have it, have
yes,
it.
because
If there
otherwise-
might be something
there might be, otherwise, if that happens,
Ah.
then
Ah.
matter may be different, your lordship.
different. That I think you are. That I think we should give him a
That my
chance.
review is required.
Ah.
But they may continue, may not continue, that is required.
because it is general, not in relating to that Ajay Chaudhary's case. Here it is general. We therefore directed currency of a suspension of thus not its of a suspension order should not extend beyond 3 months. Okay. So in your case, not extend. If within this period the memorandum of charge sheet is not served, so condition is that if not served, it will not extend. If memorandum of charge sheet is served, a reason order must be passed for the extension. There may be some that will be under suspension. Uh, No, it is silent, but there is a manual of departmental proceeding where these provisions are there. No specific date, but manual of departmental proceeding
Yes.
that is there that they will have to have an satisfaction whether the
Needs to be
extension is
continued
continued or not. That is there. Okay. The learned counsel for the state respondent submits that he may be granted some time to obtain instruction whether subsequent to filing of SARS memo on 7/9/2023, any review was taken or order was passed for extension, continuation of the suspension order in question. Prayer is allowed. List.
2 weeks after the 2 weeks.
Let's give it. 30th of January.
Of like
So we'll complete it today. You want to do add anything?
My part is remaining.
Okay, we'll hear you after this behavior. Okay?
Okay.
Because I will not be available next. That's right. We'll fix a date. Otherwise, I was thinking that I will complete and dictate this order, but may not be possible. Not be tomorrow. Then again I'll have correct it. May not be possible. Afterwards. So better we'll take in a proper, giving you a proper hearing. But still we are tilted towards it. To be frank.
All I did is start my business and take. But you have to hear me, man.
No, we'll hear you.
Yes.
We'll give you a patient here. You may change our mind also.
Yes.
It's not that. We are
I would
open.
be that.
Yes. Order now that. Order hearing on 25.
Keep your
Just remind us, this matter has gone out of. Yes, madam.
Okay. Madam, will be published by
Who is your senior?
RKD.
RKT. Just give me a minute. Oh, that scale, merger of scales, is not it? Okay, we'll take it up on that other method. We'll give it after view. That is there. That is there. You want to? You have added something.
yeah.
Ah.
Please.
Okay. Okay. Give a date after view. 23rd. 23rd? What? We'll finish up that method today.
Yes.
That this can wait for some time.
Yes.
Some like it. Just give me a minute. Just tell me the salient feature of the order dated 13/11/2003.
Your Lordship, to pay for eight, just hit for that chapter for
90.
Eight.
That's the one. 90.
paragraph number 5.
Okay.
Just prior to that paragraph 5, 3 lines in paragraph number 4. Page
Telegraph
90
number 4.
Paragraph number 4 is there.
Hmm.
Page 98 is there.
Just a minute. Huh? Page 98, para 4, 5, and para 4, 5, and last portion of page 90. Mr. Chaudhary, we have fixed it after Bihu.
Your Lordship, 23rd I will be there.
Okay.
It can be on 22nd or after 26th.
Give after or you will not be here.
I'll be in the,
Okay, can we have it on 22nd
yes, 22nd is,
or too many matters? No, he will not be able. 25th, are we available here?
no, 25th I'll be coming.
Okay. Then after 28th, give it. 30th.
30,
That is.
First-
No,
First
that
of
is-
February.
that is- So,
like to start from first line. Though elaborate arguments have been advanced by the Senate
Hmm.
for the party for and against the respective stand taken, the State court could not convert itself to a fact-finding forum to embark upon the exercise to determine the tenability of either
No,
of the
where are you reading?
page 98.
Page the date.
Though elaborate.
Okay.
There,
Okay, read.
though elaborate arguments have been advanced by the for the party for and against the respective stand taken, the State court could not convert itself to a fact-finding forum to embark upon the exercise to determine the tenability of either of the versions. This is a task assigned to the inquiry officer. Therefore, the validity of the ex parte inquiry held against the petitioner is the crucial aspect of the case to which this court has to turn. The elaborate materials on record which have been perused by the court do not indicate that though notices were sent by registered post to the petitioner, the same were duly served. Whereas CPSC has not been able to place before the court any materials to show that the notices of the inquiry were served on the petitioner, and that in spite of such service, the petitioner did not participate in the inquiry. Learned CPSC, however, has urged that as notices have been sent to the petitioner by registered, a presumption must be drawn by the court regarding proper service. This court would hesitate to draw any such presumption in the absence of any enabling rules similar to those contained in Order 5 Group. The presumption
Just
permits
a minute. Okay.
the presumption permissible under the Code of Civil Procedure in respect of issued in connection with court proceeding, and no extension thereof would be permissible in respect of notices issued in a disciplinary proceeding. We have the law laid down by the apex court in the case Union of India and others versus Jana Santaram Parekar and others reported in AR 1998 that in a disciplinary proceeding, the documents sent by the registered post can be said to have been served only when it is established that it was tendered to the addressee. This court will have no hesitation holding that the ex parte hearing inquiry held against the petitioner does not conform to the principles of nature.
I have seen.
But the main part, Your Lordship, paragraph number 6. The above conclusion reached by the court, which required the court to appropriate interfere with the final order dated 10/12/1996, which is therefore being satisfied by the present order. Next question is one of consequential
Where? The above conclusion is
paragraph number
okay.
6. Page 9. The conclusion reached by the court which required a court to appropriate interfere with the final order dated 10/12. It therefore being set aside by the present order. Next question is one of consequential relief would be entitled to. Naturally, as the impugn order dated 10/12/19 set aside, the petitioner has been considered and must be deemed to be in service all along. The entitlement back wages of the petitioner would, however, stand on a different thing. The grant of back wages always lies with the discretion of the court, which has to be exercised with the totality of the facts. In the present case, as the petitioner is yet to exonerate himself from charges leveled, I do not consider it appropriate to direct payment of back wages at this stage. Must be made clear that
Just a minute.
must be made clear that notwithstanding the directions as above, if the disciplinary authority of the inquiry held against the petitioner should be held abreast, the respondent authorities will be at liberty to do so subject to the condition that any such de novo initiated will be brought to his attention at the earliest without any delay.
Hmm.
Witness and without that, it is about.
Just a minute. Okay.
So, de novo proceedings were directed to be, the discretion was given to the authority. They proceed de novo, same charges, if so, copy the earlier charges, in it.
So in the subsequent proceeding, your case is that no presenting officer appointed.
Yes.
Huh? This is your case?
Yes. No present officer. No inquiry report was provided. No allowed. What part about it? Was the charging section
Is
Sure.
the
kind of
minor pet. Section?
section 11(1).
What it says? CRPF Act.
Yep.
Okay, section?
11. Minor 11(1). Commanded or
Just
here
a minute. 11. Yes.
the commandant of any other authority or officer as may be prescribed may subject to any good under the act award in lieu of or in excess to suspension or dismissal anyone or more of the following for any of the member of the court whom he considers to be guilty of neglect of duty or reminiscence in the discharge of any duty or any other conduct in his capacity as a member of the court that reduction in rank, fine of any amount not exceeding 1 month pay and confinement quarters for term, confinement without quarter guard for or without or other removal from any office or office special support. Now the lordship also go to section 10, which says and the subsection M.
Section?
10. Subsection M. his case quite covered by this particular section. As heinous offense, every member of the court who I'll go to straight to M absents himself without leave or without sufficient cause overstays if granted to there was sufficient cause for him to actually to have overstayed his period, and that was of course never to be. So that is why resting on this grounds of being excessive and disproportionate what has been done by that is overstayed.
Now 11.1 permits measure punishment. Is that it?
In addition,
Now when can be no, this is section 11 is minor punishment.
minor
What is the major punishment?
major punishment is at root 27 of the CRPF.
Rule?
Otherwise, the punishments are actually mentioned at root 27 because the inquiry was
No, there are I think two part. One is punishment of imprisonment and all. Other is these other dismissal, reduction in rank, fine. What are the major penalties? Punishment and penalties are two different aspects, I think.
I understand.
Then
Otherwise,
see, if you go by rule 11, rule 10, less heinous offenses. This is a categorization of offenses. If you come, why it has been categorized for the purpose of punishment. If we come to last part, shall be punishable with imprisonment for a term which may extend to 1 year or with fine may extend to 3 months pay or board. Suppose we take this principle also. Now I want to know where is the procedure of or categorization of major punishment and major penalty and minor penalty in a departmental proceeding, not in a proceeding for punishment of imprisonment.
Your Lordship, CRPF Act was weak. Because
Now suppose here it is says minor, where is the major punishment? Huh?
It-
9.
Major 9. More
Major
heinous
offenses.
more heinous offense.
One is offense. If we go by more heinous offense and less heinous offense, then if there is silent regarding departmental proceeding, so we will have to treat the offenses and correlate to it in a departmental proceeding. That's why I want to see any distinction made between the DP and a procedure for punishment. That should be court martial or something like that.
Otherwise, root 27. Page for 27. And it's right.
Mhm.
The punishments are the state. So that
So this is punishable with transportation of life for a term of not less than 7. Okay. For the more heinous offense. And less heinous offense, it is maximum is 1 year.
One.
This is two part. Now minor punishment comes. Suspension is a punishment or what? You know? Rule 11. Now, how dismissal from service is to be given? Rule 26.
Rule 27.
Just a minute, huh? Rule 27. Let us see rule 20. You have been dismissed from service,
Remove
removed from service.
but they are also trying to position of
Where do you get it?
page number 100. The statement order. So the dated 12 page 1. Second last paragraph, third last paragraph. Whereas the undersigned and completely that the case has also decided that a further inquiry should be held under the provisions of the case against the state constable driver, the people of the next page, like the bottom. Now, therefore, to understand after considering all the pros and cons of the other part covering up. First one, that further inquiry should be held under provisions of case 1965 against the constable driver of the at the state constable driver of the third rule 4 of the rule 10 of the case, right? We deem to have been placed under suspension with effect of 10, 12, 8 and shall continue to remain under suspension further on.
But page 103 says memorandum under rule 27. Because rule 27C says the procedure.
Good.
So procedure adopted is rule C of 27.
But in cases where there is a gap, so because rule 27 itself, they are silent on whether presently considered to be mandatorily appointed or they simply they say that yes, body officer should be appointed, but nowhere they mention for the present. And
But where is the presenting officer's procedure under Rule 27?
Only after first year. Prior to that, there is
Prior to 2017?
30
Oh.
But prior to that, there are Supreme Court judgment based on direct president rule book.
When is this rule came in? Here, definitely.
Rule came
Which judgment?
page number 7.5 and right upon
Okay, okay, okay.
because the inquiry officer cannot be the prosecutor advocate.
That we have noted.
But when the point
Okay.
more specifically,
Hmm.
the execute order,
Hmm.
the execute order, page number
New consideration.
New.
That you are.
the past records were accepted by the court, which cannot. And
That's all. Madam. Major punishment is dismissal and removal. And in addition to that, there may be minor punishment also. This is which what Rule 11 says. And so far relating to the imposition of penalty, Rule 27 says there is a table who is to do, and Rule 27 sub Rule 6C. C says what to be the procedure. That is, and according to you, you have followed all the procedures, and he remained absent for 60 days without leave. Therefore, according to you, he is not fit to be retained service. So, therefore, in such circumstances, a writ court should not interfere with the city.
One more thing, Lordship, that minor punishment in section 11 is stated in lieu of or in addition to. It nowhere stated that the dismissal or removal could not be.
No, that could be granted, but where dismissal would be granted? That is what I wanted
Lordship,
to.
I just one and presenting officer.
So there will be some conduct or things where you will give up major punishment, and there are some offenses or action on the part where you will give a minor punishment. Where are those? This is silent.
Lordship, but here, Lordship, one has
No,
to
no,
consider that it's armed forces, like any other.
No, that we
service,
understand.
it
Just
has to
for
be
our understanding.
Lordship.
So you also say that act is silent in that regard. That is
Major
what-
punishment for which and that is not
yet,
defined.
But they have defined what should be the major offenses and minor offenses. So his argument is, so therefore, you will have to, in view of this gap, you will have to relate to the minor offenses in case of this, because that has been treated as a principle is that is a minor. That is your case.
Lordship, I just want to place one judgment, but this is the download copy, but this is actually in AR.
Okay, which parties names are there?
Yes,
We can
Lordship.
collect.
This is AIR 2005 SC 4289.
Just a minute, I'll take out your AIR.
2005 SC 4289. An appeal by the Union of India and the Best Court.
AIR 2005 SC 4289.
428.
Okay. Paragraph 4, 5, 6, 7, and 8.
Yes. They are also in
Okay, that is one part. Just yes, and anything want to add? Want to add?
they're not on put the record of it. They are not directly produced the record. My affidavit also I have stated that after the judgment of the Honorable High Court, we have served him everything.
But it was happened. Paragraph number 20.
Of?
Of the affidavit.
Huh.
They have stated themselves. But report was no president of the
Okay. Paragraph?
paragraph number 20. They have stated
Para 20 of affidavit. Suppose that is not given to you, what will be the consequences?
basically there's a violation of principles of
Then
basically inquiry report. I could not actually control what the
properly represent. Okay, then what will be the
deny the charges,
what-
deny the reasoning given by the
Okay,
inquiry.
what will be the consequence? Suppose you hold that it is a violation, then
Your Lordship, otherwise that whole inquiry process is the case. Because
is it the law that
my understanding, because if the inquiry report is not given to me, supplied to me, I could not controvert the findings of the inquiry. So whatever, if they have to give in a reasonable opportunity of controverting those findings of the inquiry, then only after taking into consideration my views,
they could have passed the proper order?
they could have passed a proper order. And also presenting of appointment of presenting officer, the help by any, in fact, I stated in my written argument also, and this reliance on certain judgment
Okay.
as to the proper furnishing of the inquiry, why it is necessary.
The judgments are there in the.
Well-
Okay, and madam, you want to add something more?
Lordship, in my paragraph 29 of my affidavit,
Hmm.
that we
Paragraph
have served-
29?
Yes. He had also appeared before the inquiry officer. His personal hearing was also carried out, and that presenting officer, although rule doesn't permit, had he been asked for in view of natural justice lordship, that was also never raised by the petition. And rule doesn't allow him for that. It's not mandatory as per CRPF at that.
Regarding presenting officer, your Lordship may kindly note paragraph number 24, there stated that no presenting officer
Yes,
was
lordship, because it's not under rule.
According to them, there is no
No.
requirement.
No requirement. Now it is required.
Okay. We'll try to deliver it on 18th or 19th, but we'll keeping it as a part.
Highly
all are given. You have also given some note, any written argument? No?
Written argument,
No.
about the given.
Okay, your affidavit is
Yes, sir.
written. And you relied on this judgment?
Yes.
Is not it?
Yes.
I just a bit there.
Suppose, what is your date of retirement?
Otherwise, I've been told that it's 49 years of age. So can be reinstated actually 20 years of service.
As per affidavit, he is 53 years.
And he is retired.
With that, then 7.
Now, Lordship, after 2001, 20 years later,
Whether you can drive.
yes, Lordship, that is the most important thing.
Yes, of course. Lordship.
Okay, we'll see. We'll come back to you. We'll dictate in the open court. We'll
My father
prepare a
is
note.
I guess they can still drive to town. So I think that idea of
Thank you, Lordship. I'm appearing on behalf of Beach Patrol, Standing Council PTC. My Lord, we had communicated with the government and we are awaiting of instructions. May I pray for fixing the matter after a week, my Lord?
What is this?
My Lord, the petitioner retired from the service is on 2004, my Lord. It's an old matter.
With the father of the petitioner. Oh, that. Father died, mother died.
My Lord, we are awaiting of instructions.
How long will you wait for the instruction?
My Lord, we have communicated.
Where is Mr. Chaudhary?
My Lord, he's on legs. He's on.
Wait. We want him to be. Is he here in the court?
My Lord, he's
We'll wait for him.
highly open.
Let him come.
I'm saying for that.
Hmm? Punishment was? Punishment was?
Punishment stoppage of 2 annual increment of 2 years.
Ah.
With humility.
He is retired.
He is retired.
It is a matter of 2012. We are in 2024.
By that, I would say.
Where is the order?
You order is that page, my God. Page 64, my God.
start from my connector where allocation start so can so here to
Sorry. Very lenient. They are very lenient.
Yes, my lord. The recent, my lord,
Where is the inquiry report?
my lord, the two Supreme Court judgments have come last year, my lord.
inquiry report is not provided to me.
No, no.
No, no.
Provide. Specifically recorded, just provide. Have you filed affidavit?
Yes, my lord. We have found evidence. That is not his case, my lord. His case is, my lord, that 4/1/2011 movement order was not served on him. My lord, whole case is built on that, my lord, termite. Yes.
It's true, but my lord, I was not heard. That in my
Over-
defense also I have stated.
No, my lord, that is not his case, my lord. Perhaps he is not prepared.
2012. How can I adjourn this case?
Can it be a true, my lord? Let me take it up.
No, my lord,
Tuesday, my lord, I have difficulty. Let it be a true, my lord. That is not my
two is not possible. Otherwise, I will.
It's a matter of insubordination. Supreme Court judgment has come, my lord, where the Supreme Court has held, my lord, that, my lord, the discipline is a hallmark of armed forces, my lord, a non-negotiable condition of service. The other Supreme Court judgment says, my lord, that insubordination is a serious misconduct, my lord, which cannot be tolerated in a force like CRPF. The two judgments are there, my lord.
learned counsel for the petition. Submit that you will be granted some time to prepare an argument. Matter is pending in 2012. Therefore, court is court inclined was not inclined to entertain their last subject. Archive of the matter. You it better after testing. Chaudhary pension, that's why we have got it.
We were empty there only in a month of
That we understand.
September.
No, we are not,
Sometimes
as such, we are not, just we want that you do something.
Lordship, they, only on receipt of this petition, they came to know about it. They are trying to locate every document. Lordship, may 1 week time or immediately.
No, we are giving you 2 weeks time after Bihu, but might may not get the benefit as a family pension, but he will entitle for the
Something
earlier
will be
yes,
there.
earlier period, at least, isn't it?
Yes.
Mr. B. Chaudhary, learned standing counsel for BTC, submits that he may be granted 2 weeks further time to obtain necessary instruction and obtain necessary instruction in terms of this court order dated 22/6/2028. Inasmuch as the BTC has been implemented as respondent. List matter on 24. Possible that you try it, at least have some.
Paragraph 16,
Paragraph 16.
four issue of the case, it page 12. Petitioner was promoted to the post of master in the year 1984, 1984.
Okay.
But the rule at that relevant point of time. After completion of 12 years, you get the next time.
Okay.
12 years will be completing in the year 1996. In the impugn order, in between, one round of litigation was there.
Okay. He was promoted to grade of master with effect from 36
36,084.
84.
1984.
84 pursuant to earlier litigation.
Earlier.
Okay. 12 years master completed on 1796. 96. Then he became entitled for the senior scale of 7,000 from the year 9. That is from the
1799.
27.
27.
27, 1996 higher scale.
The impugn order was decided page 8.
Okay.
That started 5th of January 2012.
Page
Page 58. Paragraph B. Basis of the cases that might they have the big box is below.
Paragraph B. You have been promoted to master.
Paragraph D, ma'am.
Paragraph B.
As per Chinese School Committee Rules and Regulation 1997. That is important. I was due in the year 1996. We have taken into consideration the rules of 1997, which is not done.
So according to them,
prior to 1997 rule, masters with 12 years of service, rules were decided with P6. Page 56, next step 13 months.
Yes.
Subclause A, senior scale will be granted after 12 years of service in disciplinary grade, craft workshop instructor, physical training instructor, meeting instructor, grandmaster, training school, extend master, including art master, physical education, potential,
and master.
and master. On the other hand, will be granted the selection scale after 12 years in senior scale of the respective. So, master with 12 years. Now, 1997 rule. That was decided page 61. What are the changes?
Page 61.
61. Changes is that 12 years if I am pregnant, say 4.
5.1.
5.1. 2 financial, this ACP month. 2 financial update is 12, 24. But in between, a person gets a promotion, regular promotion, then he will not pay attendance. But prior to that, 96, master plus 12.
So they are relying on this.
Irrespective of
They are relying on this.
relying on this, and my case is that master plus 2. That is the
They say that since we have given you
in between promotions, because in master's grade was in the year 1984. Master grade was
understand.
grade was
This
page
is
11 of the
this is a scheme of 90 which year?
prior to 97. 50, page 56 is prior to 97. 60 is after. A dispute order is relating to that, taking into consideration
Page 61.
61.
They have rejected taking note of page 61.
61.
Your case is that my consideration is prior to page 61.
Prior to page.
I have acquired the qualification prior to page 60,
Page
issuance of page 61. Therefore, in terms of page 56, you are entitled
You are-
for promotion on acquiring 12 years as master for a senior scale. This is your case. Yes. What is your stand in the affidavit?
The part
Are you still working or retired?
Retired 2017.
is
If
my
that is done, my lord, that from 1996, then all representation will be as a consequence of it. And page 61, 60 and 61 has been enclosed by them along with the dispute order. That has been the entire scheme has
They say that this is not automatic but by selection by a screening committee. Where is that? Where do you get it?
that is annexure 1, page number
5.04.
5.0. Page number 10 of affidavit
Page number 10.
10.
Isn't it?
Page number senior selection, that is 5.0. While senior scale will be granted after 12 years of the master, as this, the selection will be granted after 12 years service in senior scale of respective cadre. And my lord comes to 5.059.
What is the senior scale and selection scale? Selection scale is higher. Selection grade type.
Great set.
within master they created two
Select-
codes, two grades. One is entry, another is select.
So what is senior grade?
Page 11, little higher in page
Okay.
8 and 11.
So it's a senior scale. You get a senior scale, then you get a selection grade.
Initially, they
made it three categories: entry, senior, selection. Thereafter, in 98, they made it two: general scale, senior.
Now, how you say that they are require a selection?
That-
Kindly see your clause 5.04. Read it.
I put,
Your document, page 10,
yes,
annexer 1.
yes. 5.04,
Yes. That is you rely.
yes,
You say that because of this we could not give. There a selection is required.
Yes.
Read it. It is automatic as per your document.
if you updated senior citizen there, may be treated evidence of confidence given to the procedure laid for this. We have stated in our affidavit in our position, based on that.
You have stated at page 2, page paragraph 5.
Yes, page to paragraph 5.
As per
Yes.
the rules, promotion to the senior skill is not an automatic time-based
Yes.
promotion, but based on selection by a screening
Screening
committee.
Maintained as per.
Rule 2 assumes that the rule is as annexer 1.
Yes,
So
sir.
we are at annexer 1. Which rule says tell us?
That kind of page
Uh,
5.05.
5.05.
05. To be eligible for grant of selection with a master or an assistant master, as the case may be, should have served in the senior scale for minimum period of 12 years and should have satisfied the carried out the duties of the house master minimum period since the appointment of selection date will be made on the basis of seniority subject to the rejection of the unfit. The senior scale and selection scale will be given to the district after screening their satisfied performance during the process preceding 10 years by screening committee comprising the following. For grant of selection state, the screening committee will be chaired by inspector, that is regarding after
That we understand. Screening
Yes.
committees understand that it is from the date of the screening committee. Where is that? Because screening committee examine, they got the period 12 years is there. So when he's completed 12 years, he will be entitled. Where is that from the date of only? Because entitlement is 12 years completion.
Yes.
But not only 12 years completion, there is other criteria that
Other criteria,
and should have satisfactorily carried out duties of house master from minimum 3 years
yes,
in the
yes,
Sainik
yes,
school.
yes.
So he's having both these. Therefore, you have granted him. Isn't it?
Yes.
But you say, where is the impugn order?
Page 58. Page 50.
Yes, 58.
Hmm.
Chapter 14.
Understand, where is the rejection? So you have completed 12 years when, Mr. Sharma?
12 page number 1, 1190.
And you have been granted senior scale from when?
So they have given me a different page, altogether different. Because in between the six CPC came.
No, no, that you understand. Scale is different, but have you taken you, they have given the scale of the senior scale or not?
Yes, they have still. Senior scale 22 6 1996.
Which
It is-
effect from
By the order dated
22
22 6 1998.
order dated
Which effect that is the order dated. Order dated 22 6
annexer
1998. Annexer 8 page 37.
which effect from
Which effect from 15 7 1990.
15/7. This is granted as senior or
Senior.
selection?
Senior.
Senior and senior. So you should be 12 years will complete on
1 7 96.
can that be?
I think I see it. This is your completion of period of service that is we have stated in page number 5 of
No.
my definition.
Top 94 knowledge to be 96 knowledge because master plus 12 years. I was
Yes.
promoted to masters on 36 1984. Plus 12 years, it will be 1 7 1996.
1 7 96 12 years. Okay, so 12 years you become 1 7 1996. Now you have been granted with effect from when?
Yes.
Or not in not even granted.
Not even granted.
Now
Because I have been placed in a different scale.
no understand. Now why you want to set aside this order page 58?
Because it is as
What
per
is the determination made in this? Let us see that first. First it says you file a representation
Yes, madam.
for fixation of pay in master grade we effect from 1 7 1984.
Sure.
Okay. Why 1 7 1984?
Because I was promoted to masters on 36 1984.
Okay, 36. Where is that order? In terms of High Court's order.
No, the prior,
It is
prior.
Your claim is that you should be your salary should be fixed in master grade with effect from 1 7 1984 and promotion to senior scale and selection grade and refixation of seniority as master.
Because of that wrong calculation, not taking into consideration the pay scale of rupees 7,500 to 12,500, effect from 1 7 1996. The consequential relief, consequentially, I got the less payment. And in fact, in similar circumstances, persons have been at page 15, paragraph 21 have stated
I'm not getting anything. Have you filed anything? Any raised anything?
No,
Because paragraph 5 of the state says, in case of any discrepancy, you are requested to confirm the same to this office with 1 week from receipt of this letter. Thereafter, it will be assumed that the matter has been resolved.
yes, not. Because
Then
the
how
interim
will you
order-
go back to all this now? Because employers should get a chance that what is wrong, what is not
The last
wrong.
paragraph it is there.
Huh?
Last paragraph it is.
Because we are not
Yeah.
getting anything what they have decided. We do not know whether you have understood anything. What we can gather from this, that where is your application dated 5/12/2011? Because this has been decided on the basis of your application. Then we'll understand what is your grievance.
There has not been.
Then how will you know?
But you know that there is an indication that they filed an application.
Because this has been decided on your application. So we must understand what is your grievance. Then they are understanding and they are determining. And they said, this says we have answered it. If you have any grievance, please clarify us. If you don't, then we presume that this has happened finally.
Subsequently, there is no communication. With
The pay has been fixed as 2006.
So that we understand. To come to a conclusion that is that fixation is wrong,
Yes.
we must understand what is the wrong.
Yes.
No, neither of three of us is able to understand what is wrong. Forget about me. Both of Mr. Sharma is not even. Then he'll come to you, then to me. Isn't it?
what I could
That is-
understand, madam,
I am not getting anything.
I'm not getting anything. Absolutely.
paragraph 18 of the writ petition lordship will file the background of the case. May I read truly?
Yes.
Page 13 of the writ. More like a gist of the case. That the petitioner begs to state that he was promoted to the master grade with effect from 30/6/1984. Accordingly, as per third pay commission, his pay was fixed with a scale of rupees 550,900 with effect from 1/7/1984. That is the date, my lord. The fourth central pay commission came into effect from 1/1/86. As per fourth pay commission, pay scale of rupees so and so pre-devised of master grade PCT was revised 1642-2900 and his basic pay was fixed at rupees 1700 as master grade PCT. The fifth CPC was implemented with effect from 1/1/96 and the pay scale of the that is
149, 293 was revised to rupees 6,500 to 10,500, revised paper from 1196. In terms of the recommendation of fifth pay commission, the basic pay was fixed at 7,001. Petitioner had completed 12 years of service. That is the case. 12
What
years
is
of
the
service.
reply in reply to paragraph 18?
They have basically reiterated their
But they are
Four of our application in the Facebook. There are
para 9. That got the statement which is paragraph 18 and 20. The repetition, the deponent said that the petitioner was promoted to master effect from 1st of July 2024 effect from 1st of July 2024 month by month with all consequential benefits in terms of the rules and regulations due to him in law, which were duly audited and vetted by LA, Controller of Bank. All the pay commission implementation during period 1st July 1984 were duly and correctly taken into account in the pay data. For the benefit to do the regulations, the masters and assistant masters were considered for grant of senior step for 12 years. They have also applicated. Mr. Ramoti Roy joined so
But we get that as per society rules and regulations, every teacher can receive a maximum only 2 in-service promotions during their entire service. Where is that? Teacher subsequent 2004.
these are subsequent. Because prior to that, I was
The whole case is that till 90s on such and Thursday, I became eligible for the selection grade. You have not granted on the ground of subsequent notification of 1997 under ACP scheme, which was not even made applicable to me. What is your stand on that? Have instruction and go through your
Yes.
take a copy.
Yes.
We know
take it.
you are also reading right now.
Yes,
Mr. Sharma reading yesterday night also not been able to convince her.
only at morning I got the message that he has and these methods are very
Okay, MS Gayan Learned Council for the representing. See here issue is you see his paragraph 8.
yes, yes,
His paragraph 8 is the whole grievance.
Yes.
That I am entitled automatic promotion after such and such.
Yes.
Okay. And these are the conditions. 2 conditions, 12 years and 3 years serving as
Serving.
something. If I have served 3 years in Master Guard or something like that, assistant master, then I am entitled.
Yes.
You have deprived me on the basis of ACP scheme formulated in there 1997. So therefore, that cannot be made applicable to me.
Yes.
If that is so, he has retired, you will refix it and whatever, what not you will do.
yes,
Alive?
Alive.
Sure? Otherwise, will not do this.
family.
there are things,
Huh?
That family.
he is from, I think,
That
South.
family. Okay. That's it. That's it. Brief according. It's some accommodation. To reconstruct the file. Mr. Sharma, give a copy, both
Yes,
affidavit and okay. According to the statement, there is allowed this matter after. In the meantime, she may
Yes.
collect the copies of the petition as well as of the affidavit from Mr. Sharma.
We'll make a note also.
He just suddenly come, everybody is in vacation mode. Yes.
Matter pertains to non-payment of pension.
May
Family.
please your lordship.
I'm on behalf of Mr. J.K. Goswami, standing on PTCL. My lord, they have filed additional affidavit. We have not received copy. my lord.
Additional affidavit when?
It was filed on 1/8,
1/8
1/8, 1st of August.
to 2023. Pursuant to order of this court dated 18/7/2023, the petitioner has filed an additional affidavit
On 1/8,
on 1/8,
2020.
1/8, 2023.
Yes.
It is not on record, but 1/8, 2023. Copy sharp,
We have not received.
but we have not received.
It was filed.
But we have served to the senior government representative.
I am on behalf of standing counsel APTCL.
Okay. Okay. The learned, you are Mr.
J. Borman.
Mr. J. Burman, learned counsel appearing on behalf of the standing counsel APTCL, submits that they have not been served with a copy. The record also reveals that the copy was served in the office of the senior government advocate, Assam, not to the learned standing counsel. Accordingly, matters stand adjourned enough to enable Mr. Sekia to serve a copy
Right now,
have a copy of the additional affidavit dated 1/8/2023 upon the understanding counsel, Mr. J.K. Goswami. Within a period of 5 days from today. List this matter for hearing after view.
okay.
After mark view.
Mushan and 8 years.
None appears for the petitioner on call. So, as a Gaya Garden City is present, represent the Indian. None did represent the petition on 49/2023 when the matter was according to repression stands dismissed for non. If there is order, event.
Yes, but the others are not, not here. This is regarding PSO matter. PSO, PSO matter. Withdrawal of PSO. Personal security officer.
Anything survived?
The survival means that we are under interim order, we are getting protection.
Well, vacate is peaceful everywhere. Why you need PSO?
No, because that is there.
Where is the state?
And the government
Everything is, if you have seen recent, all problems are solved.
the government is supposed to file an affidavit.
Why should public money
regarding
be
this
wasted
special-
for your PSO?
No, we are paying for that.
Huh?
We are paying for that.
We are
Monthly
paying
order.
for that, but there is a scarcity of person. Yes, what you say?
Lord, we would like to file a short affidavit, my lord,
Okay.
for the government of Assam on Monday, my lord.
On Monday, what we want to file affidavit?
Yes, my lord, by
Okay.
Monday.
MS
R. Borua, my lord.
R. Borua, learned counsel, appearing on behalf of the Advocate
Yes.
General,
Yes.
submits that the state will like to file an affidavit by additional affidavit
Yes,
in
sir.
opposition by Monday date given.
After what, maybe please to fix it,
No, we'll fix it Wednesday, but by Monday,
yes, sir.
by date Monday, 8th of mm, January 2024. Accordingly, see press format measurement. Prayer is allowed. Prayer is allowed. Please this matter after view. After view, in the meantime, they may file reply also instead of adjourning.
Yes, my.
Huh?
In the meantime, the interim order shall come.
He's worried about the
Oh, after, he's, my.
Okay. February 1st week.
I think
Some urgency is on our part.
But you are seeking adjournment.
An affidavit.
We said everything is peaceful. Why you need PSO? That will be your stand also.
That is, no, the SSRC recommendations are there. We just want to bring on record the SSRC. That is what we can by Monday.
Do you want to give them protection PSO?
Now the SSRC has taken a decision that the threat assessment is not there. And on that basis, SSRC has recommended that the SSRC in respect of the jurisdiction to be. So that minute has to be brought. By
Why?
Monday we can.
Huh?
By Monday we can.
The website Monday, then when better quickly.
But if we file by Monday,
You are having urgency, you are waiting to file it Monday, but they are saying somebody is having,
well, the last
okay, before vacation, no.
yes, on 11th or 12th. On 11th or
According to
12th.
better sensation and be listed on 11th of
11th.
January.
By Monday we'll file.
Interim order passed earlier. Yeah.
This matter relates to the petitioner, my lord, he is working in this Guwahati planetarium.
Okay.
1994.
Okay.
Earlier, my lord, while he was denied payment, my particular payment, he approached the honorable court. After the direction of the honorable court, my lord, he now you
Wages.
yes,
Now, what is the present status?
present is
Getting.
working, my lord,
Working and getting the wages.
getting the wages from 33 rupees to now 23,000. 33 rupees per day started working, man.
Now,
Now it's
getting that scale.
23,000
Scale. Minimum of the
per-
scale.
per month. But prayer was there.
Who is for the other respondent? Mr. Bapujari, she was working as a Safai wala. She is still working.
Well,
On, in terms of interim order, wages she is getting.
well,
To pay her the regular that Upendas or what? Is it possible? Go through it. Since she is getting,
my lord.
now she is getting 23,000.
23,000.
So if she can be given that benefit, subject to what you say.
If he is getting 23,000, that means
That-
he is getting more. If Upendra is to be applied, then he will
No.
get less.
No, maybe her scale is at the age that we do not
Yes. No, so in,
23,000.
yes, because in Upendra's lordship is there, my lord, the
Uh-huh.
decision bench has taken a cue, my lord, from the dictaments of this state. So this thing stated, my lord, minimum of the pay scale. Now, here, my lord, the post Upendra's, of course, finance department has issued few notifications whereby, my lord, it has been, my lord, promulgated that, my lord, that the minimum of the pay scale plus, my lord, some medical insurance,
Okay.
house rent allowance, everything is there. But since he is getting 23,000,
So what is your status now?
My lord,
How many days your service is left?
my lord. He is working from 1994.
Or now what is her age?
Age, my lord, as per the affidavit of the
40 years
at
on
the time of
2013.
time of filing this petition. Now, he already he completed 30 years of time. Another 10 years to go.
In fact, in the writ petition, my lord, he is claiming for regularization of service. Regularization perhaps, my lord, is not, my lord, permissible, considering the nature of employment, my lord, of the writ petitioner. Now, my lord, so far as, my lord, payment of salaries and, my lord, the increase in the
Why
quantum.
should we disturb her? She is getting paid 23,000, let her have it. We'll adjourn this matter.
My lord, another thing is there, my lord, earlier two workers were working, my. So while one, other one was denied, my lord, regular payment, so he left the job. Now this lady is working for two,
So you walk instead of we are going further.
he is working.
Mr. Barpuzar will fight tooth and nail that this person should not be regularized, they should not be given salaries.
No, in fact, my lord,
They will rely on Jagdish Singh,
No, no.
Upenda,
my lord, it is
what not. So later we'll tell you that please this matter for hearing in the part 2 hearing.
my lord, in the affidavit, my lord, in the affidavit, my lord, in the affidavit filed by the administrative department, my lord, an OM of the finance department has been enclosed,
Hmm.
whereby there is a specific bar created, my lord, that so far as this kind of posts are concerned, my lord, there will be no regularity.
Forget about regulation. Continue her till 60. Pay her whatever
Of
she is
course, my
getting.
lord, the administrative department will have to take a
You
call.
file an affidavit how much is getting under what circum. Okay, then we'll consider whether which one will be benefited.
Because her primary relief is, my lord, with regard to regularization. Lordship, that is not permissible.
Oh, we can mold the relief. Is that it?
My lord,
Are we powerless?
no, my lord.
Then he is getting by virtue of court order. We are not inclined to decide today itself
My lord. Therefore,
to
my
go
lord,
to all these niceties of law.
my lord, because prima facie what appears to me also, my lord, is that he is getting more.
Don't say that. You're getting more.
No, my lord, if offenders is to be applied, then, my lord,
Therefore, we want to know
yes,
how she is getting
yes,
it.
yes, lordship is absolutely correct. Yes.
Okay. The present petition is filed for uh, file regulation of service and claiming enhanced fixed wages. It is submitted by the learned counsel for the petitioner that the petitioner that the wages of the petitioner has been enhanced from time to time pursuant to the order of this court dated 27/5/2013 and currently is getting at wage of rupees 23,000. The learned counsel for the petitioner submit that he may be granted some time to bring on record the enhancement made and the order hereto by way of an additional affidavit. Prayer is allowed. List after 6 weeks.
Probably.
May please.
Yes.
Lordship, this matter is for non-release of income determined gratuity, Lordship.
Hmm.
Lordship, same is not so far contention of the accountant general is concerned, Lordship. Same is not released, Lordship, due to not having sufficient qualifying period of services.
Hmm.
In the last earlier occasion, Lordship,
Hmm.
I furnished to judgment passed by Honorable Supreme Court, Lordship,
Hmm.
and according to this Honorable Court, instructed my senior clerk of accountant general
Hmm.
to Lordship verify that judgment. One is Lordship flame thing. For perhaps Lordship judgments are in the record.
Yes, Mr. Dhar. What is whose responsibility to confirm the service? What is the criteria for confirmation? What is the criteria for confirmation?
This case Lordship, confirmation is not required since Lordship after counting of all the service period, my service period will be more than 30 years. If it is less than 20 years, then question of confirmation will occur.
No, let us understand the confirmation. Suppose less than 20 years. It is whose responsibility to confirm? Employer. What are the
Employer.
criteria for confirmation? Okay, suppose a person is appointed not against the sanctioned vacant post, but he continued for long years, his service was regular. Forget about Uma Devi and all that. Service was regular. Now he continued his service. Qualifying period is suppose how much?
20 years.
20 years. 20 years. He has his service is confirmed. Confirmed means it is against the vacant post. Now here qualifying service is 10 years. Then okay, suppose it is not confirmed. Now what is the criteria of confirmation? When can we confirm, when not? Any criteria? So it is luck and chance. So on a luck and chance, a person in whose time there is a vacancy, his qualifying service will be 10 years. Suppose today a person is serving 11 years, but during his time there was a vacancy, so his service was confirmed on 10th year or 9th year. He retired next year, 10th year, he is entitled for pension. A person junior to him, or maybe he is having a junior in age who is having 14 years of service, but retires next year. There is no vacancy. So he will not be entitled to pension. In both the cases, nature of recruitment is the entry casual. Both. Two examples I am giving. Both. One, because there is a vacancy, he will have a pension. He is serving more than 14 years. He will not have. Because he has served 10, they will have. You will need a judicial pronouncement in that respect. Suppose what will happen to him?
We find a bit. Only counting of past services will not solve the problems. And already similarly situated person has received the entitlement.
You are only interested in your case. We are interested in a
Not-
different level.
not-
So you take your seat, please. You are interested in your case. No, you know, we understand. Yes, you choose to contact. But your confirmation is subject to availability of the vacancy. Now, what is the meaning of regularization then? No, let us come out of these dicey affairs. What do you mean by regularization? So they are a second category employee. So if government service, they are regularly inducted, where is the question of confirmation? If there is no post, how can you make them a regular servant? On that ground, you will not give somebody promotion. On that ground, you will not give somebody pension. Only on the ground that so don't regularize. If you have once regularized, they are in the government fold. If they are in government poll, their qualifying service will be 10 years. Where is the question of confirmation? Oh, that is a case to case different. Can that be a basis of principle that no, all regulations are, this is your action, not any action of him or the court. Pension is a very valuable route, right? A person will give service for 14 years, he will not get pension.
pension, my lord.
I have received the family bill.
Go.
This year.
No, we are on the earlier case also. This we are facing it every day. So we want to resolve this. What is your case in this?
In this case, Lordship, my case is that my husband was initially appointed on 8/3/1981 as master of labor.
The family pension, otherwise he is entitled.
Thereafter, Lordship, he was promoted to the work as hospital.
Getting pension.
I am getting the pension, Lord. If it is counted,
What do you want now?
This year.
if this year, this come determine capacity, Lord. Capacity only because of Lordship, 1 year best qualifying service, Lordship, I have not been paid. My
If
case,
1 year less, 1 year less. What the
Lordship,
rule says?
rule says, Lordship, that has to be counted, Lord. As per even Sangita Rai also,
No, Sangita is something different.
Lordship,
It's totally different footing. It was there was a notification
Yes.
how to give. That was it. There was a deduction that was challenged before this court. This court says no, you cannot make this. That clause was set aside. Went to division bench. Division bench said this will be made applicable to others also.
this is also similar, Lord. I'm going better. My case is that, Lordship, my husband was appointed on 8/3/1981 as master of labor. Thereafter, he was promoted to the post of boxer Chokidar on 16/7/1991, and his service was regularized. So the same regularization, which was followed in the Sangita case, with effect from 22/7/2005. So far, my calculation, my casual period of casual service is 10 years, 4 months, 8 days as master of labor, 14 years, 5 months as boxer, 7 years, 11 months, 8 days Lordship regular employer. After the date of my husband, Lordship, family pension was pension, Lordship, but income retirement gratuity was not pension. Stating that after deduction of initial 3 years of services, Lordship, it becomes less than, Lordship, become less than 20 years. Now, Lordship, this period of services is required to be counted as per, Lordship, the law laid down by the Honorable Supreme Court in Prem Singh. Subsequently, one more judgment is passed by the Supreme Court, Lordship. Here, the Honorable Supreme Court says,
What is the
Lordship,
citation of Prem Singh?
Prem Singh is 2019-10 SCC 516. Another latest judgment is, Lordship,
2023.
2023, Lordship. 2023 says whatever required period of services is required, only that must be counted, Lord.
What was Kopiram Rajbangshi?
Copyright responsibility counting of past services under Rule 31. That is pretty strong lengthy process. Sorry, sir. As per Sangita, whole period of services is required to be counted. And so far my calculation, my period, whole period, total period of service is 32 years, 4 months. Sir. The required period is 20 years. Sir.
What is your stand?
Then this, I have
Only this year.
CCL.
Who is aspirant number 5? What is the stand of the Accountant General?
Quite affidavit on a parastic matter stated matter parastic.
What is your stand?
With regards to statement on parent paragraph 4, it is replied that disease officer officer was not confirmed in his service, and due to that, is not entitled.
So according to you, for DCRG confirmation is required.
Yes, this matter.
Where is that?
Matter is parastic matter.
No, I will keep this matter part third. I want to expand.
Yes, matter.
Hard in part, please this matter on.
Okay. In this case, I have filed one reply affidavit
Place this matter on. Mr. Bapujari, be here. You also. 8th of February 2020. We want to understand what is corporation.
Yes.
Yes, Mr. Chaudhary. Anything urgent? You are here.
In this, the first issue that has to be decided is whether it will be pre-view or post-view.
Post view.
Sir, termination of
Because
probation.
pre-bihu, I'll be in your state.
I see.
So therefore, almost tomorrow is the last. I do not want to keep anything for.
In any case, this will require some time because
That's what-
termination of probation, your lordship will have to go into all those motive, foundation, and all those.
Okay.
Prior to that, my lord, there are other people who are not even called for interview. They have accident there.
There are two groups of writ petition. One group, they had questioned this election. Now, I appear for IOC.
Hmm.
We conducted an inter.
Somehow I dealt with this case for in
That
one
come up
occasion.
for admission one.
Yeah, for admission, it had come up.
Okay.
So basically, we conducted an internal examination and we found that the allegations are correct. Thereafter, we
That's why I was a little bit surprised why Mr. Deka is sitting here when there is no second appeal.
He is venturing into other
Other
interesting areas.
so any interim order?
There is
They are working.
no,
But
not to fill up.
you will have an urgent.
Like when we have the young boys, they've been terminated without.
What is the allegation? Why terminated?
Termination, there were some anomalies in the selection.
They're wrongly.
You are against him.
So one set of petitioners questioning the selection process,
Okay.
and pursuant to that, we conducted an internal inquiry, and there we found that the allegations are correct. So accordingly, we had to terminate. And against the termination, Mr.
So
Deka.
there cases that you could not have terminated us like this.
That's
Very
quite limited.
You are limited.
Our case is that since we were a probationer,
No.
we did not go into further detail. We did not conduct a inquiry, full-fledged inquiry as such.
So you will rely on the APSC system.
APSC, and also there are several, your lordship is aware, for long list of judgments.
Okay. As agreed to by the learned counsel for the parties, please dismiss.
And it has to go after 5th of February. Till then, your lordship is, Mr. K. N. Chaudhary is appearing. He will be busy with the wedding in the last week.
Give a date.
Huh? 13th of February.
13th of February. Any interim order? No.
Interim order.
Interim order, pass earlier, shall continue till then.